Hello and welcome, dear aspirants, to Rungta IAS Academy for another crucial explainer for your UPSC preparation. Today, we're dissecting a highly relevant case study for your GS Paper 2 syllabus, the Bhojshala-Kamal Maula complex dispute.
That's right, sir. This editorial analysis is an absolute goldmine for understanding the intersection of the judiciary, secularism, and historical claims. Let's dive in and build up that conceptual clarity for both your mains and the interview round.
Okay, so here's our roadmap for today. We've structured this exactly like a high-yield mains answer. We're going to blitz through the context of the dispute, the Places of Worship Act of 1991, recent judicial actions, the impact on contested sites, and finish up with your exam focus.
Perfect. Let's jump right into the first piece of the puzzle.
Right, so we're looking at a recent editorial that provides a really phenomenal, completely neutral lens to view the recent developments in Dar, Madhya Pradesh. The focal point here is the Bhojshala-Kamal Maula complex. Now, this is a site with a very mixed architectural heritage, and it's had competing religious claims for well over a century.
Exactly. And the source text presents a very strong core argument that shared use of such disputed sites should simply be allowed to continue. This is a critical perspective for maintaining social harmony, which, as you know, is a massive theme in your governance and social justice modules.
So let's trace the timeline, aspirants. It's moving fast. The Places of Worship Act theoretically froze the religious character of sites as they existed on August 15, 1947. Understanding that context, back in 2003, the Archaeological Survey of India actually established a shared use arrangement for the Bhojshala complex to accommodate people of different faiths.
But let's fast forward to 2024. In January, the Chief Justice of India revived proceedings, and then we hit a critical turn. On May 15th, the Madhya Pradesh High Court ruled that the complex had been a Hindu temple. They even suggested the Muslim side seek alternative land from the state. Yet the court insisted it was only determining the site's religious character.
And that brings us to a major legal friction point that you absolutely must understand.
So, the core legal friction lies right between two specific provisions. On one side, you have the strict mandate of the Places of Worship Act 1991. Remember, this was designed specifically to prevent these backward-looking historical disputes. However, Section 4.3 of that very same act explicitly exempts ancient and historical monuments that are covered under the 1958 Act. Because the complex in Thar actually falls under this 1958 Act, it created a massive legal loophole. It's allowing current litigation to proceed despite that 1947 freeze.
And the editorial gives a brilliant term to this loophole, calling it a procedural side door. Aspirants, please note this phrase down in your study materials right now.
Oh, absolutely. If you use the phrase procedural side door in your mains essay when you're evaluating judicial actions and the hollowing out of legislative intent, it just shows exceptional analytical depth. The editorial impartially points out that utilizing this 1958 exemption completely bypasses the fundamental spirit of the 1991 Act.
So what exactly are the judicial foundations for these recent findings? Well, the editorial highlights the court's heavy reliance on the value of archaeological evidence. It actually draws a direct line back to the Supreme Court's 2019 Ayodhya judgment.
Precisely. It uses those exact same principles, the preponderance of probability, and the whole concept of faith and belief. Furthermore, the editorial critically notes a really interesting dynamic. While the Supreme Court is staying civil suits, it is allowing PILs, public interest litigations, to achieve functionally identical outcomes in what is a highly polarized terrain.
Which leads us to the broader implications, the domino effect. The editorial is warning us that the Ayodhya precedent has basically paved the way to repeatedly challenge the status of minority religious sites.
Because if these contested sites are also protected by the Archaeological Survey, they become totally vulnerable to that exact same procedural side door. The editorial explicitly points to Gyanvapi, Shahi Idgah, and Bija Mandal as sites already facing this trajectory, which really compounds the complex issues surrounding Indian secularism.
So, from an analytical standpoint, what is the way forward? Let's move to the editorial's concluding thesis. It strongly advocates for a very strict enforcement of the 1991 Act.
Right. The core argument here is that the courts shouldn't really be entertaining determinations of religious character, especially when it comes to title disputes that were already pending at the time the 1991 Act was enacted. The focus absolutely must shift away from adversarial litigation and get back to democratic coexistence.
Sir is absolutely right to highlight that. This is a perfect, high-scoring concluding remark for a mains answer dealing with constitutional values and dispute resolution. Dropping a quote like this elevates your answer to a very mature, governance-oriented perspective.
Finally, we want to leave you with a highly provocative question drawn directly from the text, an excellent simulation for your UPSC interview. Adversarial litigation so often involves courts asking, what was there first? But the editorial challenges this whole premise by asking, why draw the line at medieval conquest and not go back to pre-Hindu histories?
It challenges you to really think critically about the arbitrary bounds of historical litigation. So how would you answer this before the interview board? Think it over, structure your arguments neutrally, and keep studying hard. Thank you for joining us at Rungta IAS Academy for this explainer. We will see you in the next one.